Good morning, good afternoon, good evening. It's Patriot Smoothie here to summarize day 31 of the trial of Tamara, Lich, and Chris Barber. Today was a day that was dedicated to the Crown's response to the defense's application to dismiss the Carter application. The Carter application was brought by the Crown, where the Crown is trying to have words and actions of one of the co-accused, Chris Barber, apply to the other co-accused, Tamara Lich, and the defense is saying that there's not enough evidence to meet the three rungs, the three cycles of the Carter test. The fact that there was an agreement made is the rung one, the test one. The second test would be the furtherance of the unlawful design, the conspiracy, and the Crown was grasping at straws. I mean, I thought plastic straws were illegal in Canada, but the way that we're seeing them reach for them here, I guess they're taking heed of that recent federal court ruling that said that it was unconstitutional for the federal government to ban plastic straws, and they're grasping. Boy, are they ever grasping. And I want to give a quick shout out to the Democracy Fund. They're the only people I can find doing an update from the courtroom today, so thank you very much. We're going to be going through quite a bit of their reporting today, and depending on that to get the picture of what happened. And I'm going to add context from my opinion and the previous reporting that I'd done on the trial to try and highlight some of the things that the Crown is talking about here and bring it into a bit of my perspective for you. So let's dive right in, and I've highlighted the points of today's coverage that I think are really of interest that we need to talk about. So first and foremost is the Crown stood and began to address step one of the Carter application. The Crown stated that they did not have to prove every element, but adds that the unlawful agreement occurred somewhere between January 29th and February 21st. So basically, I guess, the day the trucks rolled in and then the day the police action happened. And at some point, the agreement to the common unlawful design, the criminal conspiracy of the inherently illegal action that Chris and Tamara agreed to participate and further together happened in some time between the first day of the convoy protest and the last day of the convoy protest. Very specific and narrow there. The next thing to talk about is that a reference from the Crown with statements made by Barber on January 29th. And I want to talk about this because it's important. It's something I haven't heard this level in the trial before. We've heard a lot of Chris's other statements, but in this one, some frustration and some other things come through. And I want to talk about it really quick because it's important to be transparent and to give both sides an equal weighing. And so in these statements on January 29th, I don't know where they were made. I think maybe in a TikTok or a message it doesn't say. Chris Barber said that we are completely messing the city up and we bleeped this town up. And then on the next day, January 30th, said that it's the city already locked, we train wrecked it. So he said these things. What are his actions? What are the evidence? In Chris Barber's actions, we saw him amenable and working with police, trying to clear up blocked roads when there was just too many protesters and vehicles, that it created a physical dilemma in the fact that the road may have lost at some point an emergency lane or two, but it was never at a point where it compromised emergency responses. We heard that at POEC. We heard that from Kim Ayotte in this trial as well, who said that all the city's response thresholds were maintained. Every building was accessible to emergency services. There was no excessive response time at any point during the entire convoy, and they did a review of that. So Chris Barber did everything he could to work with it, but this thing just got so big from the grassroots across the country that there was some streets that did lose access, but certainly not for a lack of trying of good faith on Mr. Barber's half. So I think it's important to weigh his actions versus his words. Another thing, so the Crown says that what we saw occur over those 3 weeks we are able to infer intent. We saw cooking, tents, stages, the use of horns, fireworks in the presence of exhaust or fumes. So those things mean the fact that there was tents and fumes means that there's a criminal intention and inherent unlawful design and a conspiracy between Christopher Barber and Tamara Lich, apparently. Next, so the Crown says that they're not going to show the videos again, but they need to be considered because they provide important context. The Crown adds that the evidentiary gap closes when you see how long the closures and obstructions remain. Okay, we can't prove that when the agreement happened, we can't prove that this was inherently unlawful, but the fact that they remained here closes the evidence gap. That doesn't make any kind of sense. The protest remained at the state that it remained in, and that doesn't close any kind of evidentiary gap. There's no evidence that this agreement happened. There's no evidence that Miss Tamara Lich and Mr. Chris Barber came to Ottawa with the intention to do anything inherently unlawful. and the furtherance of that, the second rung. Don't get us started, because that's what today was about mostly. They're trying to prove the agreement, which is the first rung. Then there's the second rung, and then there's the third rung. If any of those tests fail, the entire Carter application fails, as I understand. So another thing the Crown said in another video on February 5th, Chris Barber's walking on the streets and bumps into individuals who ask for pictures with him. The Crown notes their excitement. He states that Lich and Barber were not ordinary protesters; they were the leaders of this occupation. So I wanted to bring this out. That's what the Crown said. They're using the term occupation again. They haven't used that. The Crown hasn't used that term since their opening statement, at which point the defense basically objected and said, we don't like that language. And Justice Perkins McVeigh issued a guidance that, we tend to avoid that. And so the Crown hasn't used that language since the very beginning, and now they're bringing it up again. That should tell you a little bit about how they're feeling, maybe. They're trying to use that language to paint a colorful picture. I'm surprised that the justice didn't remind them to use, remind them of the language that counsel has been using. And the fact that people were excited to see Chris Barber on the street, he's a nice guy. He's got a good aura about him. People like him. He's approachable. Approachable people tend to say hi to each other. I know that's a foreign concept to a lot of people nowadays, where you can't approach anyone or be friendly to them, especially someone like Chris Barber, who does have a social media following. That doesn't mean he's the king of the convoy. That doesn't mean he has command and control of the convoy. It doesn't mean that at all. What a reach. Next, the Crown puts up a text exchange of January 9th where Chris Barber writes, "We're finally starting off." In another text he writes, "Park on the highway, shut it down. I want store shelves empty." So that's from earlier, before the convoy was even in Ottawa. I want to add a little bit of context to this. There's been a lot of discussion for many years in trucker circles about frustrations over trucking working conditions, working pay stuff. There's been a lot of talk for years in the trucking world about strikes and things that they could do to basically have a legal, lawful protest against things that they deem unacceptable in their working environment, whether that be the time away from family, the low pay, the mileage rates, the owner-operator concerns. And that's a common theme in the trucking world of parking the trucks and having an effect from that, but certainly not an inherently criminal intention, and certainly nothing new or radical. It's something that a lot of truckers have engaged in a long time. That's the way that I see that, a potential way that I see that comment. Another Facebook post from January 12th where Christopher Barber writes about conducting a slow roll. The Crown states that slow rolls obstruct roadways and the flow of traffic. Well, that's interesting because we also just very recently heard evidence where Chris Barber actually consulted police on these slow rolls, and I believe Officer Bache, the main PLT contact with Chris Barber, said that it was a good idea or something like that. So next, the Crown referenced a statement made by Tamara Lich at a press conference where she said, "We will continue our protests until we see a restoration of what is right." A reporter asks if she would return if mandates were re-implemented. Lich responds, "I think you would see that in short order." And the Crown, following up on that, the Crown says that the use of the pronoun "we" being used, and submits that the common purpose among Lich and Barber, remember the common unlawful purpose, the common unlawful design, and all other protesters, is the removal of the mandates. That's not inherently unlawful, though. That's the problem. The Crown adds that the purpose is an unlawful one, blocking the roads. Well, that wouldn't be the purpose. The purpose is to remove the mandates. That would be the method, and that's not what was done. We saw throughout the protest efforts from all parties to keep roadways open and accessible. And then the Crown adds, assembling unlawfully such that fear results. Because people don't like something doesn't make it unlawful. Because someone fears something doesn't make that fear reasonable. There's a lot of things to be said about that. That's a reach, and that's speculation even, maybe. Next, the Crown states that we heard about this fear in the testimony of Paul Jorgensen, who was confronted by a gaggle of hooligans about wearing a mask. Well, you can go back through my coverage about that particular testimony, but one thing I want to add about Mr. Jorgensen is that on re-examination from the Crown after the defense cross-examination, Mr. Jorgensen was asked about Bank Street or South or something, why he didn't like going in that area, and he said that he observed a random person or whoever, overdosing on the street, and that the convoy was both didn't care about it, and that they blocked emergency services from responding. Now, the defense didn't even object to that, and I think that's really telling. And Justice Perkins McVeigh at the time interjected and added something along the lines of, unfortunately, people overdosing in Ottawa have nothing to do with the convoy. So I think that and also I remember Mr. Jorgensen testified about food insecurity. Then he was asked about other food sources in the area that he could have gone to that were open, that he said something about his backpack not being big enough, or that he didn't like it. I don't recall exactly, but you can go through my reporting and see what he said. That needs to be considered when examining the testimony, that kind of testimony from, and then there was other things too. So next, the Crown is playing a video on February 5th showing a number of people and trucks on the streets in Ottawa. The Crown states this doesn't happen by accident. It is evidence of an agreement. So people coming to the streets of Ottawa is evidence that Tamara Lich and Chris Barber made an inherently unlawful agreement. It's not evidence, of course. It's preposterous to think that this could be because people were frustrated in coming to Ottawa to protest in a grassroots lawful way. No, that couldn't be the case. This means that there's a criminal conspiracy afoot. Next, the Crown reiterated that what they submit is threatening conduct, including protesters laughing at people for wearing masks. Now, we did hear some testimony along that lines again, but at other points in those individuals' testimonies, we heard things that were raised questions about the rest of their testimony for sure. And even if you could find somebody laughing at somebody wearing a mask, that's not a threat. People get laughed at all the time. It's not inherently threatening. It's not a tumultuous action that makes something a riot or an unlawful assembly. It just doesn't work that way. I don't think so anyways, and I think a lot of you would agree with me on that one. The Crown referenced a message published by Ottawa Police on February 6th where they cautioned the public against bringing supplies to Ottawa for the protests. It may constitute a criminal offense. The Crown submits that this shows the escalation of the police response. Just because the police are escalating their response doesn't mean the thing that they're responding to is unlawful or breaking the law in any way. Sorry about that light back there, guys. Let me see if I can maneuver around. The Crown states the meaning of hold the line is not speculation. It is a statement to further an agreement to obstruct police. The Crown based this on the instructions police gave to protesters to leave certain areas in Ottawa. Well, let's go back to what Justice Perkins McVeigh said a few days ago, that hold the line can mean a lot of different things to different people. It can mean stand true in what you believe in and to your values. And Perkins McVeigh actually said, just because an officer says it doesn't make it lawful. The Crown actually agrees. They have to agree because it's true. The police can say things that are not lawful. They can give unlawful commands that aren't that you're not obligated to. Now, you always comply with police, but that doesn't mean everything that they do is lawful. The Crown states that the bottom line with respect to step 1, which is the agreement, is that there is ample evidence to make out the requisite standard. What evidence? You don't even know when the agreement happened. You're saying that trucks parked on the street and people protesting in Ottawa is evidence that Tamara Lich and Chris Barber agreed to an inherently unlawful common design. It's a reach. It doesn't make sense. And then the Democracy Fund adds, recall, step 1 of the Carter test is the agreement with an unlawful purpose. The Crown moves to submissions on step 2, which is the furtherance requirement. These are different steps applied in it is the exception to the hearsay rule, commonly referred to as the co-conspirator rule, the Carter application, right, as we explained. So the Crown moves to submissions on step 2, which is the furtherance. The Crown displays a picture of Tamara Lich and Chris Barber in front of Barber's truck. Oh no, a picture. He states the Crown states that the photo was on Wellington Street. Perkins McVeigh asked if this was directed there by police. The Crown says that they were not directed, but perhaps welcomed by police. Well, in fact, we heard evidence in this trial over and over again that the police gave protesters a map of exactly where they were going to go to park and to do the protest when they came into town. So I don't know what's going on there. The Crown moves on to another photo of Barber's truck parked outside of Wellington. He notes there is no similar evidence of Miss Lich, of course, because she's not a truck driver, but adds that this is furtherance of intimidation by obstruction. So Mr. Barber parking his truck on Wellington is furtherance of intimidation by obstruction. And I believe the area that Mr. Barber was parked in was the one that was like wide open nearer to the Supreme Court, if I recall correctly from the evidence. I'm not too sure. I'll have to refresh my memory on that one. All right. The Crown notes that these photos display Barber's end of the agreement by his direct participation in the agreement by parking his truck on the road. But what's the agreement itself? You say common unlawful design to come and protest mandates in Ottawa. That's not inherently unlawful. That's not a common unlawful design. And then the Crown continues that they add that Lich's presence on the street along with her intent is sufficient to make out her participation. What's the evidence of her intent, first of all? And then that her presence on the street, the fact that she was there, it means that she was furthering the common unlawful design. It's not even a common unlawful design to come and protest, so how could her being there be a furtherance of that? And what was she doing to further it? Standing there? Come on. Give me a little break. Perkins McVeigh asks about intent regarding the text messages between Officer Batch and Barber, where the two are agreeing to reduce the footprint. Barber makes attempts to exit with his truck, but is blocked in. The Crown responds that there is direct evidence of Barber blocking the street, and that takes us to lunch evidence. But that doesn't really answer the question. What does that tell us about the intent when there's text messages between Mr. Barber and his primary police contact where he's trying to actively reduce the footprint, get trucks out of residential areas, and the Crown responds to that by saying, well, there's evidence of him blocking the street because his truck was there. I don't know. I don't know, folks. Next, so we're back from the lunch break. The Crown is displaying another photo to the court which depicts Barber and Lich standing outside together in Ottawa. They're standing together outside in Ottawa? Come on, guys. Somebody's got to call the Emergencies Act over this. This cannot stand. Only they can stand. Outside in Ottawa. The horror. The horror. Next thing you're going to tell me there's going to be cooking and tents and feeding people and anybody can come and participate and leave at any time and there's no violence at all? What a nightmare. And he says that the Crown says that this is the photo of the Freedom Convoy Facebook page. Oh, the horror. Next, the Crown references appeals Barber made to others to come to Ottawa to join the protest. The Crown contends that this shows a furtherance of a common unlawful design. Come and protest with us. That's furthering the common unlawful design. So I guess every protest out there who invites people to protest is in a lot of trouble. They're furthering a common unlawful design, I think. The Crown says that with respect to the plan, references a statement made by Barber where he encouraged a slow roll because we can't fit everyone downtown. The Crown submits this goes to furtherance of the common unlawful design, I assume, as well. So we're going to have people park outside of the city. They can't come and park downtown. There's not enough room physically for them on the roads. So instead they're going to do like a little drive to take one lane. We talked it over with the police. The police said that sounds like a great idea. And we're going to do that. And they're going to, so that those people who can't park directly can feel like they're participating in the protest. But that's furtherance of a common unlawful design, even though it's been worked out with police and you can't physically fit everyone downtown, and you don't want everyone downtown either, and they're trying to give you a little bit of something. All right, well. The Crown turns to a TikTok video Barber posted where he asks everyone to come to Ottawa. The Crown states this is indicating of a furtherance of an unlawful plan. Sorry for that. I can't flub the word today. Yeah, so come to Ottawa and protest. That's furthering of the common unlawful plan, of course. Perkins McVeigh interjects and says that the defense will argue that this was simply encouraging people to protest peacefully. The Crown responds, absolutely. So what was the point of that? Because that's what they will say, because that's what it was. I mean, there's no evidence to the contrary. He didn't say, come over to Ottawa and disrespect police and don't listen to anybody and do whatever you want and block everything and anyone you see with a mask, go and laugh at them. Didn't say anything like that. There's no evidence of that. He just said, come to Ottawa and protest if you so choose. He's not forcing anyone to do anything. Come on, let's be reasonable people here. The Crown notes that sometime we can see statements of present, past, and future action. The Crown continues we can also see encouragement of others to join. The Crown submits that what can be inferred is that all of this was in furtherance of a plan to flood the city and overwhelm police. The first part of that, we can see statements of the past, the present, and the future sounds like I don't know what that sounds like, some guru stuff. Maybe I'm listening to a yogi here. And then the Crown continues that we can see encouragement of others to join. And somehow they leap from that to say that this is evidence of furtherance because they want people to come and flood the city and overwhelm police. Meanwhile, Chris Barber in literally every video, if, maybe not one or two, says respect police, give them shake their hand, tell them they're doing a good job, listen to them, obey police no matter what. Come on. Let's be real. So the Crown asserts that this goes to furtherance as Barber. Okay, sorry. So let me see here. I lost my track here. All right. So the Crown submits that 2 days after the honking. Oh, wait, hold on. So the Crown, let's go here. The Crown submits that 2 days after the honking injunction, Barber told truckers to discontinue honking unless police approach their truck, in which case Barber said that truckers should honk. And I think he explained in the video that he said that was an emergency signal to legal observers and to lawyers to come and observe what's happening. And the Crown says that the fact that he said that goes to furtherance as Barber advised truckers to violate the order. But I really don't think it plays out the way that they say it does. I think he was more or less indicating that it was for emergency use to have legal observers and lawyers come and see what's going on and be party and witness to the things that are happening. The Crown now addresses a TikTok video that is not in evidence. Crown says that it forms a basis for one of Barber's texts, which he writes, it was a TikTok video to mess cops up. The Crown adds that the contents of the TikTok video can be inferred from the subsequent text messages. The Crown goes on to say and read on more of the text from Barber. The cops have been messing with us. We're messing with them back. So he's expressing some frustration in text messages. Again, we have to look to the evidence. We have to look to the actual actions that were done where he's telling protesters with whatever power he has, he's certainly not the king of the convoy, to respect police, to obey police, to tell them they're doing a good job because they are. And he goes on and on and on ad nauseum like that. But, if he's expressing some frustration in text messages, again, we need to look at the actions and the evidence. That's important. The Crown goes on and read more text saying that police are being something, time to play back, and another text, hold the line. We heard the police say hold the line. We heard everyone say hold the line. The Crown adds that these show a conscious effort made by Barber to mislead police. Meanwhile, he's actively cooperating with Nicole Bache on literally everything, even when he's extremely frustrated, even when he's being stabbed in the back. He's still trying to recover whatever is there and works hard. He cleared at one point 40 trucks and 100 and something total vehicles on one day, and then the next day the deal was shut off by the Ottawa police, by the way, the day after the good faith agreement between the city and the protesters was exercised. Chris Barber and others were able to move over 100 vehicles, and then the next day the police just said, no, we're not doing that anymore. And even after all that, Chris Barber still tried to recover. And so he may have been a little bit frustrated, but his actions show that he was still amenable to working with police, still respectful, still trying to do the right thing. So I think that needs to be weighed the most heavily here, the evidence and what was actually done. The Crown is now turning to Lich regarding Step 2 furtherance. The Crown references instances where Lich used the phrase hold the line. Again, hold the line seems to be like 90% of the case. And asked the court to consider what this meant to certain protesters. What it meant to somebody, this is a whistle. This is turning somebody... Greenspun stands, thank you, Mr. Greenspun, and states the Crown has changed the position regarding furtherance and wants an opportunity to prepare a response. Justice Perkins McVeigh states she will provide ample opportunity to respond and that she will not hold them to the strict reply rules because of this, I assume because the Crown just keeps changing its footing. So the Justice Perkins McVeigh is going to let the defense's reply be a little bit more open-ended because of the pivoting going on here, is what I gather from that exchange, more or less. All right, next. The Crown now references a press conference where Lich says, we are calling on all levels of government to end the mandates. A reasonable request. In another video posted by Lich on Feb 4th, she says, we have switched over to a new platform, the Royal We, apparently. Give, Send, Go as opposed to GoFundMe. Thank you for the clarification there, TDF, the Democracy Fund. The Crown emphasizes the use of the term we, stating that this is inclusive language that should be attributed to Barber. How should that be attributed to Barber? He didn't say it. It was Tamara Lich who said that. And so what? They're raising money to buy food, to do this, to engage in a peaceful protest. It's not inherently unlawful to do that. And we could see that there's a substantial amount of support. We saw, $10 million in the GoFundMe and then $10 million in the Give, Send, Go stopped every step of the way and showed a tremendous amount of support from across Canada towards this protest here in Ottawa. That's something to be remembered and thought about and put into context. Next, with respect to the letter from the mayor's office, the Crown submits that the mayor's office was trying to reduce the pressure on the residents, and they had declared a state of emergency a few days prior. Well, maybe the protesters were trying to reduce pressure on the residents because they didn't want to be there. They wanted to be on Wellington Street. Which they could have been, and they wanted to be in other places. They didn't want to be wherever they ended up because you saw from the different ends of the plan as they were coming in, as the police were showing the different groups, the West Convoy, the East Convoy, the whoever convoy, where they were going. I believe it was the ones who went up Rideau or Nicholas or something. They got kind of stuck. They ended up this place, and then they spilled back over into the residential areas, and that was something I believe that Mr. Greenspun talked about a few weeks ago. Another statement by Lich, the Crown brings up, where she addresses the Prime Minister. Lich says that until the mandates are lifted, we will hold the line. Lich continues, this is my hill. I want you to come to Ottawa. If you can't, pray for us. So we're going to keep protesting peacefully. If you can come, please do. And if you can't, send us your prayers, your thoughts, whatever you can do. We appreciate it. Thank you. And, that's totally inherently unlawful in Canada, I guess. The Crown asked the court to also consider what was not said, specifically disassociating themselves from other groups. The Crown states that the only clear disassociation was from Patrick King. Perkins McVeigh states that she recalls a number of other protesters who were not aligned. I'm thinking she's thinking of the Rideau Sussex group, etc. Perkins McVeigh continues, defense will respond that they took measures to engage in a lawful protest, including consulting with lawyers. The Crown agrees and argues that Lich and Barber received inaccurate legal advice, but they still tried to get legal advice. They still tried to do the right thing. They still tried to tell people to listen to police. They tried to do the right thing. They got accountants for the GoFundMe and the Give, Send, Go. They got bookkeepers. They did what they could regarding the enormity of this grassroots phenomenon and how quickly it grew, and I think that they did a really good job, and I think the evidence shows that they did a really good job, that the event was peaceful, and they certainly weren't in command and control of every single person there. In fact, none of the police witnesses could find a single person in their notes who told them that they were there because of either Chris Barber or Tamara Lich. What kind of king and queen of the convoy are they when they spoke to hundreds and hundreds of people and not one person told any of these police officers that they were there because Chris or Tamara? Doesn't establish that. Doesn't establish king and queen of the convoy. They had social media influence. They had voices. They weren't in command and control. People, this was a grassroots phenomenon of Canadians from across the country, from coast to coast to coast, who were tired and just wanted to be heard, so they went to Ottawa. So the Crown ends their submissions for the day on this point. Mr. Greenspan stands and addresses the constant changes to the Crown's position on the furtherance submissions. Greenspan asks when defense will receive the Crown's final position on the matter. And I guess Perkins McVeigh directed them to send a particularized request to the Crown and ask the Crown to respond prior to tomorrow. I think it's going pretty good. I think the defense is making the points that they need to, and it's certainly heavy right now, and I will continue to summarize. I know this video ran a little bit long. I wanted to go through more of it. Maybe going off the top of my head is a little bit difficult right now with everything going on that I'm dealing with. Thank you, as always, for watching. Let me know what you think of all of this. Drop me a subscription if you're on YouTube. Subscribe to the channel. I'm going to continue producing these videos, and drop a like. It helps me so much. Everybody watching Facebook, YouTube, wherever, thank you so much. Have a great night. I'm Patriot Smoothie.